All rise. This Honorable Court of Appeals is in session. Please be seated.
Good morning. Anything we need to take up before we get started? You may call the next case, please.
Samuel Randall Friedsam III versus Frankie Michelle Krisle.
And we will hear from the appellant.
Good morning, judges. I'm Michelle Hauser from Rutherford County, Cannon County Bar, and I'm here today representing the appellant, Ms. Frankie Krisle, with regard to a parentage action that was before Judge Mark Rogers. We have three issues that are before the court today, and I will just get into the heart of the matter. This action involves a minor child, Emily Faith Friedsam.
I'm sorry.
Oh, I'm
Did you
sorry.
reserve any rebuttal time?
Yes, 4 minutes, Your Honor. Please.
4 minutes. All right. Thank you.
Thank you, Your Honor. This involves a minor child, Emily Faith Friedsam, whose date of birth was September 12, 2016. The father in this particular case did not have much to do with the minor child until he filed his petition to establish paternity when she was approximately 3 years of age. Our major contention in this particular case, it really goes to issue 1 and 2. 3 is kind of a tertiary type of issue, but really, I understand that this court only looks to an abuse of discretion when it comes to the trial court. And in doing so, the court has to look to whether or not the court's finding was beyond the law, and certainly if the findings were not consistent with the evidence that was presented. And that's where really our argument lies in this case. Specifically with regard to anytime the court is going to make a finding as to a parenting plan once a paternity has been established, and paternity was not really an issue here, it was more about the parenting plan, the court must look to the limiting factors first to see if there are any limiting factors as to that parenting plan. Now, my client acknowledges that we do have we have to maximize each parent's ability to parent, but that doesn't necessarily mean, pursuant to the case law and the statute, that we come out at 50-50 right out of the gate. We have to look first to those limiting factors as stated in 36-6406.
Did you cite that statute to the court? Was that specifically relied upon?
Yes, Your Honor, on page 10.
Okay.
In that particular statute, the permanent parenting plan and the mechanism for approval of the permanent parenting plan shall not use the dispute resolution and the parent's resolution time provided in the permanent parenting plan or temporary parenting plan shall be limited if it is determined by the court based upon prior order or other reliable evidence that a parent has engaged in any of the following conduct. And with regard to number 2 specifically, physical or sexual abuse or a pattern of emotional abuse of the parent, child, or another person living with that child is defined in 36-3601. To that issue, we called the only expert that testified in this particular case, and that was Dr. Mathis. Dr. Mathis testified before the court. His report was also made evidence to the court. And Dr. Mathis's testimony and medical conclusions were ultimately uncontroverted, in which Dr. Mathis opined. The incidents from seemingly minor to significant when taken together represent a pattern of behaviors, and that pattern of behaviors represents underlying emotional disturbance. Mr. Friedsam has acted towards women in ways which have been manipulative, deceptive, harassing, and abusive. The important thing is we're not talking about just personality features or tendencies, but made the determination that it is a disorder, and disorders are very important in making determinations about how an individual is going to conduct themselves, because a personality disorder tends not to benefit from experience and guidance, and so they're going to repeat the same pattern in an inflexible and enduring way. I'm going to be realistic with you. That's very difficult to change a personality disorder. The only recommendation that Dr. Mathis made was that Mr. Friedsam was to go to counseling. He, in fact, did that, but that still doesn't negate the big pink elephant in the room that my client, Miss Krisle, had been the subject to a pattern of emotional abuse. Even Father admitted to some of that in his own testimony that he had engaged in that.
That's what I want to address before we get too deep into this. What actually did the trial court find occurred?
They didn't really find anything had occurred with regard to that. What the court said was that the court found that there was no abuse to the child. The court never addressed whether there was any abuse to the parent or anyone else that lived with the child.
So how do we analyze that?
Well, Your Honor, I think that's where you go back to the evidence. So does that evidence ultimately preponderate against what it is that the court found in awarding a 50-50 schedule?
Is that the job of the appellate court?
Well, I think it is when it comes to as far as the abuse of standard.
Well, it depends, doesn't it? Don't we look at the findings of fact made by the trial court?
Yes, and you do certainly give them preference.
And the trial court made what findings here?
The trial court ultimately found that Mr. Friedsam presented no danger to the child, and then ultimately found every factor in favor of my client, or at least equally with Mr. Friedsam, and then ultimately put in a 50-50 parenting schedule. That's what the court found.
Did the trial court implicitly find that he did not do the things that he was alleged to have done? Or
No.
Did the trial court just not make a decision?
They never addressed it, despite the evidence being there that there was this evidence of abuse to the spouse or to the parent of this child. He only addressed this to the child.
So in summary then, and correct me if I'm wrong, you've got a situation where you contend that the record supports findings that the husband, the father, did certain things that would invoke the protections of the statute, and the trial court never determined whether or not those events occurred.
That's correct. That's our position.
And that's supported by the record, I assume?
Yes, Your Honor, it is.
Okay.
He never addresses the abuse to the parent, only as to the child.
Well, I'm hesitant to ask the question, but I will go ahead and do it anyway. Was that called to the attention of the trial court that no findings were made in this particular?
Yes, Your Honor. So after the court made its ruling, I respectfully submitted a motion asking to alter or amend, and I did cite that in my motion to alter or amend in going back to the trial court, that he had not made those particular findings.
And what was the result of that?
He just denied my motion.
Without any additional findings, I'm assuming?
There were no additional findings to my recollection, no.
Right.
The second matter is with regard to get back to my, whether the trial court erred by awarding a shared parenting schedule and not limiting father's parenting time as dictated by 36-406 when there was clear evidence father had willfully abandoned the child. At the time of this trial, father had only visited with the child one time on an overnight type of basis, I believe, and even then he ultimately didn't finish his visitation and called mom to come and get the child because he could not control the child. He didn't send gifts to this child. He wasn't active in the child's life. He knew nothing about the child, but yet the court did not find that there was an abandonment or a willful abandonment by Mr. Friedsam and this child, and ultimately ruled that he was to get a 50-50 schedule.
And
Now,
I'm assuming the same analysis goes here as well.
that is correct.
You allege specifically abandonment. The trial court failed to make a finding, so here we are.
That is correct.
Okay.
That is correct. So to that effect, I mean, like I've stated, I mean, really our argument is not whether or not the trial court erred as to that they made a mistake, a material fact of law. What we're arguing is that the evidence preponderates against it, or logic and reasoning preponderated against the court's finding, which is ultimately what was found in Haas versus Knighton, as I cited in my brief. So that's really the crux of where our argument is that the evidence preponderates against it, or it is or the logic and reasoning as it was submitted to the court. Like I said, the court found every single factor in favor of Ms. Krisle. There were a few factors that were found equal. There were no factors found in favor of Mr. Friedsam, but yet he still awarded a 50-50 parenting schedule without considering the abuse to Ms. Krisle or making any findings with regard to Dr. Mathis's testimony. He heard Dr. Mathis's testimony, and what he ultimately stated was, well, Dr. Mathis said he needed to go to counseling, and he's doing that. So, that was just the basis of that. Again, I think it goes to based upon the whether or not the evidence preponderated against the court's finding, and that's really where we hang our hat in this particular case, because we did have an expert that testified that this had been a pattern of abuse. So. And then the last tertiary issue was with regard to a witness that we had intended to call. This was during the COVID-19 protocols that the Supreme Court had put forward, that the 16th Judicial District had put forward. Judge Rogers would not allow that particular witness to testify via Zoom, as she had an issue come up with COVID-19. She was in the state of Alabama and could not travel to the state of Tennessee based upon her exposure to that COVID-19 and the amount of time that she would have to let lapse to go back to work. I asked the court
Ma'am, did you file a motion requesting that from the court?
I did not. I did on one other witness, but this person came down with the COVID right before the trial. I didn't find out about this person coming down with the COVID until like 2 days before the trial. So I did not have the opportunity to file that particular motion in a timely manner that our local rules allow for. So I did ask the court, pursuant to that, to their order where it states that they are to that they were to allow those particular things if the facts demanded. So that's the remainder of my time, so I'll reserve it for the rest.
I've got one question. Did you
Yes,
make
sir.
an offer of proof on that?
No, I did not, Your Honor.
Thank
I
you.
did not.
Thank you.
Good morning, Your Honors.
Good morning.
May it please the Court, Ben Lewis from the Rutherford County Bar. On behalf of the appellee, Samuel Randall Friedsam, I want to start with a few of the points that Your Honors have brought up as it relates to what has actually occurred in the trial court. Firstly, as it relates to the first issue brought up by the appellant, that the court in some way, shape, or form failed to properly consider the factors or evidence under 36-6406, I would submit that that simply is not the case. The court did consider, and the record is clear that it considered, several allegations against Mr. Friedsam that were made, none of which the court found rose to a level of any significance. What the court found was that both of these parties, and I will quote in my brief on page 12 at the very bottom, this is from the record, being transcript volume 5, page 72 of the record, that the parties' problem has been their inability to put aside their personal likes or dislikes of each other, which the mother considers to be some type of misbehavior on the part of the appellee towards her, making her feel unhappy or less than she would otherwise like. That, in sum, is how the court viewed the actions between these parties. There was no filing of domestic assault charges. There was never any type of order of protection. No police were called. And in fact, the appellee, in this case, the mother, rekindled her relationship and admitted to the same on several instances with the appellant or the appellee.
Are you saying the trial court made findings?
I am, Your Honor. I am saying that the trial court considered all of these issues, that the trial court, in fact, considered the fact that there had never been domestic assault charges. This is the transcript, volume 3, page 119 and through 121, where the court considers that there were never any filings of domestic assault charges, there were never order protections, there was never police called, the parties rekindled relationships. The allegations laid against my client, Your Honor, were in their entirety that he had, quote unquote, manipulated, lied, played games and tricks, that he physically charged her on an occasion, on one occasion threw a couch cushion towards her, and in another knocked a water bottle from her hand. That was the entirety of the allegations that were brought forth in the trial in this case that took place over 3 days, Your Honors.
And the court found what about those?
The court ultimately found that both parties had engaged in essentially mutual manipulation or attempts to of each other throughout this, and that it was a matter summed up by the court's ruling that their problem was their personal likes and or dislikes of each other, and that they needed to put that aside. The court found that if it came down to it, these parties would have a basis for divorce, but this was not a divorce proceeding. The court went through, in my opinion, the record's clear, a pretty painstaking analysis, even jumping back and forth from different portions of the custody statute in Title 36 and Chapter 6, that there were, went through the factors of 36-6406, jumped to the definition section. There was, in about an hour-long ruling, probably 10 to 15 minutes of it, I would estimate, on just the issue of 36-6406 and then those tangential issues as to the facts, Your Honor. The record is clear in the court's ruling that they considered that statute specifically, and all of us in the bar in Rutherford County know Judge Rogers is meticulous. He is very intent on going through every factor as it's set forth in the statute, even to some frustration from some from the bar sometimes. But that's for this court's benefit when it comes to these types of appeals, is that he does in fact lay out facts and factors that he has considered, Your Honors.
Did the court make any explicit credibility findings regarding the parties?
Your Honor, I don't recall exactly. I think, again, kind of summed up in the last portion of the court's ruling that these parties essentially just don't like each other, and that's what the court felt. The court made different rulings as to credibility for each one on different portions, ultimately finding that each one had engaged in essentially attempts to use the other one and or manipulate. There were allegations and specific allegations that were, again, not refuted by the mother, of attempts to use sex to manipulate the father on some occasions. The court did ultimately find, as it relates to the mother, that the reasoning for fathers not being involved in the child's life was specifically her refusal to allow any meaningful relationship to flourish, because he was restricted on his visitation by her, that he could not see the child without her being present or in a public place. Not being an established father, he didn't have much recourse other than to come file a suit, and while he may have delayed that to some degree, I believe that occurred in roughly 2018, and he filed this case in 2019, Your Honor. So it wasn't significantly delayed. But as to one of the credibility factors that for the mother was that she had significantly hindered the father's relationship, and the court specifically considered that in making its ruling as well. There were several factors that weighed for and against both parties, I think, for their credibility, and I think ultimately that's why the court, in the end, did not find that there was any basis to limit the father's visitation under 36-6406.
Well, I see where the court recites what the parties said, but I don't see where the court made a finding about any of that.
I think Your Honor made the reference to an implicit finding of going through, considering those factors or those facts, then going through the factors of 36-406 and finding that there was no basis to limit father's his visitation. I would suggest or submit to this court, as the court mentioned earlier, that would be an implicit finding and an implicit consideration of those facts, in that the court then did not limit father's visitation and found that there was either no credibility to be given to those allegations, or ultimately that there was no harm to the child from any of this. Therefore, there was no basis, and I think the language that the trial court uses is there's no basis to limit father's visitation specifically. So I would submit, Your Honor, that issue as to 366406 was considered by the court and was found to not be an issue for these parties, and ultimately did, to a degree, limit the father's
Doesn't
visitation.
that really fly in the face of Rule 52.04, where the trial court's required to make findings of fact and conclusions of law?
Your Honor, the court found the facts as in what it believed to be the facts as it set
The court
forth.
recited the testimony by each party.
Yes, sir.
There's a difference between reciting testimony that a party gave
Yes, sir.
and a finding of facts. The recitation of testimony is what oftentimes a court reporter could do, whereas a finding of fact is a duty delegated to the trial court.
You're correct, Your Honor.
So, and as Judge McGee quizzed you a moment ago, there are specific credibility findings made in the order,
Yes, sir.
but I don't see any made for the parties themselves.
Yes, sir.
So, somewhat of a quandary, isn't it?
A bit, Your Honor, unless the court reads implicitly into it that the court did not find any of these to be meaningful issues as it relates to ultimately child custody and the limiting factors under 366406.
That is one way you could read it.
Yes, sir. And I would submit that's the way that it should be read, that the court did consider, recited those, and that it ended up being essentially a non-factor, as the court states, that these issues are between these parties and don't ultimately reflect upon their ability to parent the child, separate and apart from each other. The other issue, Your Honor, is as it relates to Rule 35 report of Dr. Mathis, and whether the court, or whether the trial court properly considered his Rule 35 report. As this court's well aware, the court is not bound by any portion of the expert's finding and can either credit or discredit all or none of it. And the court did find that Dr. Mathis had done a full report. The trial court considered that, but ultimately found that Dr. Mathis's only recommendation throughout his entire lengthy report was for Mr. Friedsam, the father, to attend and involve himself in counseling, which he did, and ultimately was doing with an individual who was held in high esteem per Dr. Mathis's testimony. So he was not called, and there was objections made to this, that Dr. Mathis was not called to make any type of custody determination, solely to make a Rule 35 examination for his mental state, and his only recommendation was being complied with, Your Honor. So as to the court's consideration of that factor, I would submit that it was entirely appropriate. As to the second issue raised by the appellant to abandonment, my position on that, Your Honor, and I think it's supported by the appellant's brief, which lays out one paragraph as to this issue. The issue was not raised in the trial court as to willful abandonment. That's the facts that the mother wants to cite to, or the appellant wants to cite to, are set out in the transcripts, but as to any argument made in the trial court that the father willfully abandoned the child was not made. It's never raised, and it wouldn't be found in the trial transcript. So my position on that is the cardinal rule of appellate practice is if the issue is not raised at the trial court, it cannot be raised on appeal. So as to the second issue of abandonment, our position firstly is that should be disregarded entirely as having not been raised. As for if this court does feel that it was raised, the trial court ultimately found that the father's, or the appellant's action, the mother's actions, unreasonably limited the visitation by making it impossible for the appellee to have a meaningful relationship with the minor child. That was one of the biggest factors I think this court considered as it related to the mother, was that her own actions were really what caused any type of breakdown in relationship with this child. So, Your Honors, even if the court was to consider that issue was raised, the court considered it, or considered as to the mother's actions being the reason that father had not been able to see the child up until the time of filing his petition. Lastly, and I think Your Honors hit the nail on the head with the third issue related to the motion or the testimony of a witness who was unavailable. There was no motion filed. There was a motion filed related to a different witness, for her to be able to testify by electronic means. Ultimately, that motion was based upon some type of argument related to domestic abuse or domestic violence that the trial court ultimately denied. However, the parties agreed from a witness standpoint for testimony that party be able to testify by Zoom. However, as it relates to Ms. Kirby, the individual who is at issue in portion 3 of the appellant's brief, that was not brought up until it was time to call that individual. Respectfully, opposing counsel stood up and said that there would be another witness by Zoom. I objected on that basis, and the trial court ultimately held that that had not been brought forward and that there was no basis for it. Under Rule 43.01, the individual attempting to bring that individual by audiovisual means must show good cause, and the trial court found there was not a good cause to do that, that she should have been there. She was under subpoena. I don't recall, I don't want to say it did not occur, but I don't recall having heard anything related to COVID at the time. In fact, I recall, then I would think the record would show as to this individual, Ms. Kirby, that in fact she was on vacation in Alabama at the time and was simply out of state. But regardless, she was in fact not in the state and was not willing to come to court or testify. But the first time that was raised was when it was time, or when the appellant and her attorney sought to call that individual as a witness. Had not been brought forward at any point prior, had not been brought forward on that day of trial, nothing of that nature, Your Honors. And again, no offer of proof was made. There was no option to, or no request to have her testimony heard, no request to make an offer of proof at that time. It simply was denied and moved on. So I would submit that issue is within the trial court, and that would be a discretion issue as well. And again, even if there's no argument other than simply stating that she would refute portions of the father's testimony, there was no argument made as to what she would have refuted, and what meaningful purpose her testimony would have brought, or any basis upon which this court could find that there was anything, even if it was error, anything other than a harmless error, Your Honors. Therefore, as to the 3 issues that have been raised by the appellant, our position is none of them would rise to the level of this court overturning what is clearly within the discretion of the trial judge to make a custody and child a parenting schedule determination. And we would request that this court deny the appellant's request for relief and allow the parenting plan for the father to stand as it is. Thank you, Your Honors.
Thank you.
Your Honor, we had 4 witnesses that ultimately, we had 3 witnesses that testified, but we also had the report of Dr. Mathis that also had talked to Ms. Kirby, who was the witness that was not allowed to testify. So really, I mean, that's why I said that issue is kind of tertiary, because Dr. Mathis did have the opportunity to interview Ms. Kirby and made her particular concerns a part of his report, which is in the court's record. So that is why I said that particular issue is kind of a tertiary type of issue at the very end. But all of those individuals put forth evidence of a pattern of conduct by Mr. Friedsam that ultimately led to abuse of conflict, and also with regard to domestic, a psychological type of abuse. Counsel cited some of the issues, but one of the things that was most glaring to Dr. Mathis was where Mr. Friedsam had made up a story where he had told both Miss Brittany Kirby and Miss Krisle that Miss Varblow had a baby with him, and that she ultimately committed suicide after the baby had died. And then later on, both ladies realized that story was not true, through a third party who had ultimately come forward and said she's still very much alive. It was that pattern of manipulative and deception that ultimately went on through, and even Mr. Friedsam himself admitted it. He said, I've been manipulative, deceptive, etc. And that's what that particular statute says in 36-406, is an abuse of use of conflict is also to be considered. And again, there was not a finding as to that, as there was an abuse of conflict or a pattern of abuse. What I would state is that Dr. Mathis did say that Mr. Friedsam was to go to counseling, and he was doing that to his credit. However, what Dr. Mathis also said is that he has a disorder, and so there's very little things that can be done other than counseling to be able to help Mr. Friedsam get past it, because they are not subject to that type of guidance. So there was not really anything else that Dr. Mathis could do for Mr. Friedsam other than say, look, we'll give him to counseling and hope that that works. But still, the underlying issue remains, and is that this lady was a victim of abuse, and the evidence ultimately preponderated as to that. So our position is, Your Honor, that that all of the evidence presented together certainly goes to that preponderance of the evidence, and whether or not the court made an error as to discovering that preponderance of the evidence.
Mr. Lewis says you did not assert abandonment in the trial court. What's your response to that?
Your Honor, there was extensive testimony as to that, and I went into that in extreme amounts. I asked him whether or not he continued to pay child support when he wasn't seeing the child. Did he, what attempts did he have to visit? Did he send gifts? I also asked him in the record, who was the child's pediatrician? Who was the child's caretaker? He knew none of that. That was all designed to show the willful abandonment that had occurred, and ultimately was part of my argument as to why, under the limitations, all of that should have been considered under those particular limitations, as Mr. Lewis stated. So that is about the remainder of my time, and if there's any other questions, I'm happy to answer them.
Thank you.
Thank you. Thank you, Your Honors.
We will take this matter under advisement and attempt to render an opinion at the earliest possible time. Thank you. You may call the next case, please.
Ruth Mitchell versus City of Franklin, Tennessee.